Thank you very much, everyone, for joining us this afternoon. Please do keep your microphones on mute, but feel very free to turn on your video if you want to give us a smile and a wave at any point. There's a chat function, as we all know, in Zoom, and if there's any questions at all that you'd like to ask or points of interest that occur to you, do please feel free to jot them down in the chat function, and then during the course of the talk we'll do our best to discuss them and provide answers to those points. So this talk is part of the series hosted by Coram Chambers and Expatriate Law on an international lawyer's perspective on financial remedies. This is the second webinar of the series, and we're continuing to look at aspects of international family law. Our speakers thinking about and discussing in particular important issues that come up in financial remedy cases. And in this hour, we're going to discuss recent issues, hints, and some tips too. For those who don't know me, lovely to meet you all. I'm Alex Laing. I'm chairing the talk this lunchtime, and I'm a barrister specialising in family law at Coram Chambers. Our two eminent guests with whom I'm going to be in conversation for the next hour are Melanie Bataillard-Samuel of MBS Family Law, and my colleague Sophie Hill of Coram Chambers. Neither of them probably needs much of an introduction, but just to say a few words about Melanie and Sophie. Melanie works primarily in international family law, advising clients following the breakdown of their relationships. That includes high net worth separations, international children law disputes, financial relief after foreign divorce, and of course, jurisdiction disputes. Melanie has the benefit of being a dual French-British national and has always specialised in advising French expatriates on their family law and family law related issues in England and Wales, usually doing so in a combination of both English and French. Melanie also frequently advises and works alongside law firms in France. Sophie is a barrister at Coram Chambers. Despite her youthful look, she's now been at the Bar of England and Wales for almost 19 years. She practices in financial remedies and in cases involving and focused on children, and has a particular focus on high net worth matters. And she's being led at the moment, I know, in a number of very important and no doubt high profile cases, but she'll have to keep them, I think, secret for the purposes of today's talk. She specialises too in non-disclosure issues and increasingly in cases involving cryptocurrency assets. She balances this work with a commitment, an ongoing commitment to pro bono cases. A lot of Sophie's work is advisory as well as advocacy, and she has related experience in alternative dispute resolution. She is, amongst other things, co-author of the upcoming new edition of A Practical Guide to Family Proceedings by Bloomsbury Professional. So that is, I think, coming out in summertime, so we'll all look out for that. We have a number of topics to get through today, so let's begin. And first question, Melanie, is for you, and really it's a general question in terms of when you are thinking about the approach towards these international cases, what sort of thing are you thinking about and discussing with your clients at the very start in terms of case strategy?
Usually the way I start off is I want to know all the countries that are going to be relevant. So, you know, different nationalities, where the parties are living, if they're living in different countries, where they got married, where they might have assets here, abroad, wherever, where the kids are living, if the parties have separated and the kids are a different country, just to kind of have an idea of all the relevant countries. And when I know what the countries are, it might be one or two, it might be 3, 4, 5, then I always say, look, we need to have a conversation with someone from that jurisdiction. If it's a country that I know a little bit about,
Yeah.
I can already think about preliminary kind of, these are the points we have to worry about or think about. But usually we need to be speaking to someone from that jurisdiction, because we need to know whether we can start divorce proceedings there or here, how long it'll take, how much it'll cost, what a financial outcome might look like, whether the financial outcome will be simply about that jurisdiction, or will it look at assets in different jurisdictions. Will an order from this English jurisdiction be enforced in that jurisdiction? What will be the complications? Because you need that information to then be able to work your way back to decide what is the best place to be doing this, what should we be thinking about in advising. So that's really the big thing at the front of my mind.
So it's that on the ground practical and legal advice, isn't it? So legal advice in terms of the two things you've identified. So one, is there going to be jurisdiction for divorce and associated financial relief in that foreign jurisdiction? And two, if so, what are the likely outcomes that we're thinking about? And then the practical points that you're talking about, cost, timescales, all that sort of thing that actually really matters, but can often be overlooked.
Yeah, because I mean, you sometimes get bogged down in the whole kind of theory behind it, and then you forget of, is this really going to be the best thing for them? Is it going to be the quickest? You know, if they're anxious to have a quick resolution, do you want to be involved in a jurisdiction where you can appeal at every step of the way, and then you can be embroiled in 10 years of litigation? Or do you want to be doing it in a country where you know that within a year and a half, you'll have a final decision and that's it? So it's kind of important to have these factors considered. And also, another factor that's becoming more important, I think, at the moment is, do you need to be issuing somewhere quickly? Yeah, okay, we used to be able to do pre-Brexit, you know, first in time, that's it, it's us, end of story. Now it's not so clear. You might have petitions issued in two countries that are running concurrently. One country may choose to completely disregard the other's jurisdiction and go ahead. Another country might say, actually, no, we have to stay until we know what's going on in the first country. You need to have that considered. Yeah. And the reason I'm bringing that up is because I'm finding that the courts are becoming a lot slower issuing petitions in this country because the online system, because no fault divorce has seen a sudden, not explosion, but people were holding off issuing divorce proceedings until the no fault, understandably. But it does mean that we're not quite sure how quickly we can get an urgent divorce jurisdiction petition launched. It might be quick, it might be slow. And so that's a factor to consider as well. You know, is it worth then, you know, starting ahead of time? Is it worth looking at other jurisdictions? So that's another factor.
I mean, certainly in the news over the past week or so, there's been, I mean, in the legal news, hasn't yet made 10 o'clock on BBC, but there's been quite a lot about the delays, as you're saying, within the English system.
I mean, it was already difficult beforehand. You know, you'd have to launch it online, and then you'd have to email your local court and say, you know, this is the urgent petition I need. It's lodged in the system. Can you go there? Can you try to get it processed? And you could probably get it in a couple of days, sometimes a week. That was quick. But that was before the new system. And I'm not saying there's, you know, oh, this is catastrophic, but we just don't know. We just don't know yet. So it's something to worry about.
What about, Melanie, that balance on the human side, which is that you have a couple who are separating, but it may be actually that your client in normal circumstances wouldn't quite be ready to push the big red divorce button. And you're having to sit them down and say to them, well, look, there are these concerns about what may happen in a foreign jurisdiction. And even though we no longer have a first-in-time regime, it is something that we need to continue to think about. And you end up, I mean, I know as barristers often when we get these cases, you pick it up and you read the very gently and appropriately written first letter to the other side saying, look, we're not doing this as an aggressive step, but we just want to protect the position.
It's difficult. And I just lay it out for them and say, look, this is what I think, what I experience, what I've come across. It might not apply to you, but I really strongly advise you to consider this. Yeah. But I have had cases where clients, even just recently, actually, where clients have been like, no, it's absolutely fine. And then they've come to me and said, oh, but my ex has now issued in another country. What do I do? And it's like, well, there's nothing we can do. We now need to look at how we can work with this and how we can move forwards with it. So it's difficult. And
you get things when someone issues and they don't serve the petition in a foreign that sort of thing, don't you?
Yeah. And that, I mean, what can you do with that? That's just a nightmare. But the last point I want to raise was the issue of tax, which is another one that I think is really important that people tend to forget. Get advice on the tax implications, both here and in the other countries. Because even if you're deciding to do the divorce here, if there are assets in that other country or the other person is living in that country, there may be tax implications to consider. Do you transfer assets before the final decree of divorce? Do you need to obtain the final decree of divorce in order to deal with possible tax implications on settlement? You really have to know what's going on to make sure that you're not left with a huge tax bill and you haven't factored into any settlement, or that you haven't planned for in any way. So I do think those are the really big things to be looking at the beginning.
Yeah, well, I mean, that's obviously something really, really important, and something that we need to be saying to the client, look, we must get advice on this, otherwise there could be trouble down the road.
Yeah.
And just when you're talking about the differences between jurisdictions, obviously one difference is between what I think us family lawyers are now starting to call matrimonialization. And Sophie, I think I'm right in saying that you've been doing quite a lot of work on this sort of thing recently. So do you want to just tell us a bit about that?
Yes, that's right. I'm not sure how much traction it's going to get, because although there has been the case of WX and HX, which is a 2021 decision, EWFC 14, unlike in some other jurisdictions, non-matrimonial property, it would appear from that decision, can be considered to change the nature to matrimonial in certain circumstances. So in WX, the issue was whether husband's management of wife's separate funds in trust had changed the nature of that initially non-matrimonial asset into matrimonial property. The question that was put was, had the asset been matrimonialized? It's a bit of an ugly term. In this context, Mrs. Justice Roberts referred to cases where the court had to decide whether or not non-matrimonial property had been mixed, merged, or mingled with matrimonial property.
All the M's, isn't it?
Yes, sounds rather like a 1960s song. But in any event, the court has to consider whether the contributor has accepted that the non-matrimonial property as it was has now become matrimonial and is treated as such. And there needs to be that physical mixing and actual acceptance. So looking at the earlier case of K&L, which was a 2012 decision, the citation is 1 WLR 306. In that case, just as in WX, the assets had been kept completely separate and remained in the wife's sole name throughout. And what was decided in K&L by Lord Justice Wilson, as he then was that nothing logically justified a conclusion that as long as the long marriage proceeded, there was a diminution in the importance of the source of the party's entire wealth, at all times ring-fenced by the share certificates. So in WX, even though husband managed the funds, they did remain separate. There was never any suggestion that they be shared. They were never invested in joint names, and there was no suggestion that husband should acquire any interest in them on account of his management role. In fact, and I think this must have hurt to hear this, husband could not be said to have even beaten the market in the management of the funds. And Mrs. Justice Roberts concluded that it had not acquired a matrimonial character. Then, most recently, His Honour Judge Booth has dealt with this issue, which was raised by Sally Harrison, QC, of our chambers also.
I think he didn't like the word, did he? He's on a Judge Booth, if I remember that case.
He said, I hope it will not acquire common usage, but I'm afraid I've seen it already in 2 cases that I've been dealing with this year. So be prepared, because it's actually a really useful argument. But when you're looking at it, one has to see, are we looking at the more straightforward conversion from non-matrimonial into, say, the family home? Or is it one of the trickier cases to do with investments or joint accounts? And in L&L, what he noted was that the husband could have fixed the ownership of the party's wealth other than in equal shares during the restructuring process of a business, but he didn't do so. And the wife agreed to that approach, which essentially brought those funds into the matrimonial pot. And it was quite interesting. So I do recommend, even though it's not a High Court decision, it's an interesting, in practice, expansion upon the points I think that were being made earlier last year.
But it seems to me it's a case that's a good practical example of the slightly fiddlier way in which these issues work? Because as you said, Sophie, the simple idea is one that we're all very comfortable with, which is if you have money that looks like it's non-matrimonial but goes into the family home, well then you say it's merged, mingled, mixed, whichever M you want to use, and things are quite clear. But where in that decision of, as on a Judge Booth, you have the complexities that you've just outlined, it can become much more difficult to advise clients as to what the likely outcome is. And that judgment seems to me a helpful framework for having those discussions with clients and just thinking about how it all works in practice.
Absolutely. And I would also say that given there is this shift and this potential for matrimonialization of what started out at the beginning of the marriage as non-matrimonial property in this jurisdiction, I would endorse that as a reason perhaps to look at a prenuptial agreement in those circumstances, because it would appear that things are not as black and white as they were.
No, and I mean, that's obviously a big and at times tricky topic in itself. So let's just have a think about that, Sophie, since you've raised it, and we can bring Melanie in, I'm sure, on this. Melanie, your experience about prenups and how different courts in different countries treat them. I mean, what would you say? What can you share with us about that?
For me, prenups, international prenups, are a minefield. You've got to be really careful with how you look at them and how you consider them, because for us, a prenup is a document you prepare to plan for should the worst happen and you get divorced, you've thought about it. But for some countries, particularly, for example, those that have civil codes, like, for example, in France or a lot of European countries, a matrimonial regime, a marriage contract, a prenup, effectively, these are governing your finances during your marriage. Effectively, it's kind of like a tax efficient way of managing your finances. It's an inheritance planning. It's if you have a business or you're an entrepreneur, it's about protecting your spouse, protecting your family assets. That's how you work with it. And it changes throughout your married life. You update it, you amend it, you buy a property, you might change your regime or your contract or whatever.
So it's a living document in that way.
Exactly. And so it's considered in a different light because you look at it differently. So, you know full well that the divorce is governed by any law that's been set out in the civil code. So that's how it is. So we go at it, well, we got a prenup, that's it, we're enforcing it. But if you're looking at a foreign prenup and you're trying to implement it here, you got to remember that it's a very different document to what our prenup is, and vice versa. So what I always say to clients is, look, if you're going to enter into this document, have advice in all the jurisdictions you need to rely on this document on. And although I have some lawyers telling me it's better to have one document which covers everything, I think it's better to have multiple documents in multiple jurisdictions, but have everybody working together when you're preparing it to make sure that, for example, if it's something we want to rely on here, that it matches the Radmacher criteria. Yeah. That it's something that if we looked at it in this jurisdiction, we'd know what it is, and we'd be able to say to a court, no, this is what we always intended.
They're country bespoke, you're saying there need to be these agreements, but with joined up thinking so that there's cohesion between them.
Yeah, and you need to kind of, if you've got a French document that's for a French, you're getting married in France, you want it to be enforceable in France, by all means, have the English agreement marrying up as much as possible with the French agreement. But then you need to make sure that both documents also have what we would need here, full and frank financial disclosure, independent legal advice, signed, within X amount of time before the wedding. So the thing that exactly. The things that we recognize in a document, and I would do that for all those jurisdictions you might need to rely on it on. And then I also say to people, you've got the document. If you're going to move somewhere once you're married to go and live there, have a think about a postnup or the equivalent thereof. If you're going to have assets in that jurisdiction, or just to kind of reflect what is your intention, because we have difficulty 100% enforcing these documents. They're not something that you look at it in this jurisdiction like that's it, we're enforcing it, end of. One of the many things we look at. But in another jurisdiction, for example, I keep referring to France because it's what I deal with most, but it's the same thing in the Czech Republic, it's the same thing in Germany, same thing in Italy and Spain. That document is automatic. You know, you've entered into it in that country, it's recognized as such. So you really have to be very careful with how they're prepared, and that they're being looked after regularly, as you say, a living document that's amended throughout the relationship.
And so I guess if the client's walking into your office and it's not a client with whom you've worked previously in terms of advising them on nuptial agreements, be they prenups or postnups, you want to be really getting to the bottom of that very early, don't you? And finding out, look, are there any of these documents lurking in these various countries, and what each of them saying?
Yeah, it's definitely a conversation you need to be having, and you need to be speaking to any lawyers that they may have consulted before getting married or whatever.
Yeah. And obviously the leading case here, where the principles are set out, as we all know, was the decision in Radmacher. And just for anyone who needs a reminder about that, obviously the central ratio from that is that the court should give effect to a nuptial agreement that's freely entered into by each party with a full appreciation of its implications, unless, and this is a bit that becomes slightly vaguer, unless in the circumstances prevailing it would not be fair to hold the parties to their agreement. And Melanie, there are two things within that, aren't there? There's the procedural part, and then the substantive or content focus aspect.
Yeah, very much so. And that is something else that you have to really drive home when you've got the international documents, is that this is how we look at it here. That is what is important to us. And often it's a very alien concept to the foreign lawyers that are preparing the documents in those jurisdictions. So it is about making sure that the negotiation of the agreement, the way the advice is done, the way the disclosure is done, that it's done in a way that we would acknowledge as meeting our criteria. But also when you're drafting the document, you need to be looking at things like, you know, we might have maintenance in there. We might have a view on family home. We might have a view on making sure that needs are covered. That might not be, well, I know it wouldn't normally be included in, for example, a French document, because those sorts of things are governed by the codified laws. So they wouldn't be looking at spousal maintenance or financial support of that sort. So it's things like that you have to really be thinking about to make sure that it's a document that would work in as many jurisdictions as possible.
Yeah, I mean, it's understanding the context in which that document's intended to have effect, isn't it, really?
Yeah. And it's going to be really alien, and you're going to have some very annoyed foreign lawyers, I'm warning you. So it might be a matter of, you know, having a 10-15 minute conversation, talking them through why we need it like that, to try to make them understand that it's not us being difficult. It's just, it wouldn't be much use in this country if we didn't follow certain rules.
Yeah. And Sophie, what about the case law? Because obviously, I mean, it's been quite interesting, hasn't it? The evolution of the law. You have the starting point of the Supreme Court's decision in Radmacher, in which Lady Hell forcefully says, hold on, chaps, I'm not really sure that we're best placed to be doing this, 8 men and 1 woman to be changing the law this way. But do you want to just pick up on that and then perhaps take us through how things have developed?
Yes, I'm happy to do that. And I'd also flag that there were some earlier decisions, including one by, as he was then, Mr. Justice Wilson, where it was indicated that the prenup would have been upheld as well. So looking at Radmacher, I mean, that's really the touchstone for all of our prenup cases, but it also, of course, will impact on postnup considerations. And you've already gone through the ratio that we must consider. But you're right to say that Baroness Hale disagreed with the formulation of the test. She was actually concerned that there was a gender dimension to nuptial agreements, because the majority of the weaker economic parties will be the female spouse. And even though that was actually in contradiction to the facts before her on that occasion, because it was Mrs. Radmacher who was the wealthy lady with the family money, the gifts and the inheritance at her disposal. And so Baroness Hale asked how far individual couples should be free to rewrite their marriage contract. And she talked about the irreducible minimum of the couple's mutual duty to support one another and their children. And she considered this to be a question which should be addressed by Parliament, preferably with guidance from the Law Commission. So that happened, but 4 years later, in February 2014, the Law Commission published a long-awaited report on matrimonial property needs and agreements, and it did recommend the introduction of binding nuptial agreements. But essentially, the report concluded that the concept of fairness, as used by the Supreme Court, and which has bound us ever since, was too inexact to supply a safeguard with the level of certainty that was needed to ensure that these qualifying nuptial agreements would be upheld. And so, as with everything, there was a tranche of cases that followed. And we look at next, really, at Z and Z number 2, which was Financial Remedies Marriage Contract 2011 EWHC. And that was decided a year after Radmacher by Mr. Justice Moore. And the couple, both of whom were French, had signed a séparation de biens, excluding the default regime of community of property. And in that case, there was £15.1 million. And the economically weaker wife had her needs assessed generally. She was awarded a housing fund, she was awarded capitalised maintenance, and that took into account the standard of living during the marriage and the available resources. This contrasted sharply with the award to Mr. Granatino. And if one looks at what Mr. Granatino received, he was given an award for the purchase of a home in London and one in Germany for contact with the children who'd relocated to Germany and subsequently to Monaco. But those properties would revert to Mrs. Radmacher upon the youngest child reaching the age of 22.
Looks like a Schedule 1 award, doesn't it?
Completely. And so what was being said in that case is that he was being treated as equivalent to a claimant in a Schedule 1, where these children were non-marital. And I can see, therefore, why Baroness Hale made those comments as she was then. In Z and Z, it was a relatively long marriage and both parties had contributed. And so absent the financial agreement, assets would have been shared equally. The agreement reduced the wife's award to 40% of the assets. And Mr. Granatino, by contrast, was claiming against wealth inherited by or gifted to his wife by her family. So again, this nature of the original property was an important factor, whether it was matrimonial or non-matrimonial. And his underlying earning capacity was also a significant factor for Mr. Granatino, although it wasn't sufficient to account for his treatment in circumstances where the wife was worth £54 million and had a net income of £2 million a year. The next case that I would encourage people to look at is Vnv Prenuptial Agreement, which was a 2011 decision again in the High Court, EWHC 3230 FAM. And it was said the new respect to be given to individual autonomy means that the fact of an agreement can alter what is a fair result, and so found a different award to the one that would otherwise have been made. So actually, the prenuptial agreement can impact on fairness.
I mean, it's interesting that, isn't it, as a concept, because you've already mentioned what was said by Baroness Hale in the Supreme Court about an irreducible minimum. And conceptually, it's not very easy to align that with the idea that fairness can actually shift depending what the two parties are signed up to. And also, I think we may come on to look at this, but when one thinking about what you can do to get around the prenup, what the court can do by way of top up, if we're going to call it that, and whether that's limited to a needs claim or also extends to sharing, again, one thinks about those words, irreducible minimum. So there, I mean, there's a bit of, I mean, already just from where you've got to in terms of the evolving law, there's inconsistencies. Entirely.
And I think over time it has been really whittled down in terms of the discretion that the court's being left with, ultimately, if it upholds the prenup as fair.
Yeah.
Valid, and then whether it's fair. But a lot of the cases following Radmacher do feature chargebacks, and that's something that I think we need to advise our clients about if they're looking at prenups, because what you might contemplate at the outset of your marriage with all of the optimism that might involve, and then considering that you may then live in a home and make it your family domain for however many years, bringing up children perhaps, and then to find that you are looking at the stark reality of one day having to give up that home in circumstances where you wouldn't necessarily have otherwise, particularly if it's a long marriage, particularly if there are children. It's very difficult, I think, and it's why Melanie's point about revisiting and reviewing prenups is an important one, because I suspect that will happen more and more in this jurisdiction. The idea that you are locked into the arrangement that you entered into perhaps in your earlier years, I'm not sure that that's necessarily appropriate going forwards. And what we saw in lots of the cases involving chargebacks is really a concern that there was going to be discrimination or bias based on gender.
Yeah.
And a stereotypical view that a wife may be dependent on her husband, but not vice versa. And so thinking about, for example, I'm going to look at the July 2015 decision of Nicholas Cusworth QC in the case of WW and HW, prenuptial agreement needs conduct. In contrast to the earlier case of Luckwell and Lamata, which people I think will have heard of, any capital provision which the economically stronger wife made for the husband would not detrimentally impact on the children's lives, as they would be able to enjoy housing stability whilst with her at their home. And despite this being an 11-year marriage, the husband was limited to lifetime housing provision as a result of the agreement, with a step down of 45% when the youngest child reached 23, with the balance reverting to the wife. So I think that was perhaps a correction of the earlier concerns about gender imbalance, and trying to make sure that this was being applied across the board. In relation to the most recent case, I think that I would have found on Bailey, which was an important consideration of the principles that Melanie was setting out earlier, that if you're looking at a foreign prenup, is it going to accord with the principles that we would apply in Radmacher? I would encourage people to look at, it's a 2020 decision now, but it's S&H 2020, and it's our friend, His Honour Judge Booth, once more, who identified that there'd been no formal process of disclosure, no independent legal advice, and that the prenup had been entered into within days of the marriage, all of the things that we would frown upon. And in that case, unsurprisingly, he did not uphold that prenup. But I think if in a case of a prenup, one has to look at the procedures that are going to naturally follow, because, and I know Melanie's going to cover this, the suggestion that a prenup just becomes a factor in the case is a misunderstanding of the case law as it stands. If there is a prenup, this has to be considered, and depending on which side, obviously, if you're looking to uphold it, you need to consider what applications you're going to be making in relation to perhaps circumventing the full-blown financial remedies proceedings that you would otherwise be maintaining in this country. And I don't know, Melanie, if you've recently...
I wondered, Sophie, did you want to say anything? Whenever I'm thinking about nuptial agreements, I always am keen just to go back and remind myself of what the Court of Appeal said in Brack. I don't know if you wanted to say a few words about that also, because it may be that for those listening, actually, that's a really important decision just to be...
Well, yes, you did touch on that. Yes, you did touch on that, because that was a decision where, as he was then, Mr. Justice Francis was considering whether he was effectively limited from considering sharing in respect of the prenuptial claim. It was a decision in 2018. It was a Court of Appeal decision in which Lady Justice King noted that it's undoubtedly the case that since the Supreme Court's decision in Radmacher, and up to and including Mrs. Justice Roberts' judgment in KA and MA in March of 2018, the courts at first instance have resolved cases where there is a valid prenuptial agreement which does not meet the needs of the wife by interfering with the agreement only to the extent necessary to ensure that those needs are satisfied. And this, in my view, Alex, suggests that there's a further self-imposed limitation on the discretionary exercise that has arisen even in the face of unfair agreements. But the Brack case was a decision, as I said, of Mr. Justice Francis, and there'd been 3 prenuptial agreements. And in the first instance, the judge found that the 3 prenuptial agreements were valid and that there were no vitiating factors. However, he found the prenuptial agreements to be unfair and not sufficient to meet the needs of the wife and the children. In fact, he found the agreement would work unacceptable unfairness and put the wife and the children in a predicament of real need. However, in that case, and it's why it's perhaps a bit specific to its facts, the question there was whether there was a prorogation clause in respect of maintenance. And he found that there was a valid prorogation clause, which meant that he couldn't deal with that aspect. He was overturned on appeal and there was no valid MPC. However, before the court remitted the matter back to the judge at first instance for a discretionary determination, on the basis that without this prorogation clause, the case was essentially a conventional family remedy case, where most, if not all, of the assets had been accrued during the course of the marriage. And so the Court of Appeal was asked to determine on the issue of the finding that, having found the prenuptial agreement was unfair, the judge erred in directing himself that he was thereafter limited to making only such order as would satisfy the wife's needs. And Lady Justice King said, "In my judgment, the judge did fall into error in going so far as to conclude that the effect of Z and Z and Luckwell and Lamata meant that the wife had inevitably lost her sharing claim by reason of the prenuptial agreement." So even where there is an effective prenuptial agreement, the court remains under an obligation to take into account all the factors found in section 25(2, MCA 1973, together with proper consideration of all the circumstances, the first consideration being the welfare of any children.
So it seems to me, as I was mentioning earlier, that that point's both interesting and important. It's interesting because it doesn't, to my mind anyway, quite align with what Lady Hale said about an irreducible minimum. It's more than that. And it's really important because actually, when we tend to think about prenups, I mean, everyone's got the basic point nowadays that if they're not fair in terms of meeting needs, well, then it's not very good. And obviously the court's going to relook at things. But actually, if the question's a much, much broader one, where you look at fairness in terms of sharing, then it throws, I think, prenups into a completely different light. So I do think, just as a question of principle, that's really something for us all to be looking out for moving forward. I mean, so if you very helpfully mentioned the procedural steps and what you do when you've got this prenup and the other person, say, puts in their Form A and you say, no, hold on, we don't want to start this whole process. We've got this agreement by which we intended to be bound. And Melanie, this is probably one for you. What are you saying to your client in those circumstances if you want to short circuit that full process?
There's a couple of things with enforcing or using prenups or trying to get them upheld in our jurisdiction. I think, first of all, you can just do them by agreement, by consent. So if you both agree that you want to have the prenuptial agreement upheld, not a problem. You just do a bog standard consent order. But I would give some tips, which is you got to attach in the schedule to the consent order a copy of the prenuptial agreement so that you can show what you're trying to reflect in your actual consent order. And in your D81, really helpful to have the schedule of assets disclosed in the prenuptial agreement and the signature pages, the advice, certificate advice from the lawyers, so that the judge who's looking at this document can see that there was financial disclosure, that you did have the legal advice, that the boxes are being checked. And obviously in your D81 or maybe the covering letter, explain about the prenuptial agreement, why it should be upheld, etc. I
mean, it's like the skill of all good advocates, isn't it? You want to make the judge's job easy.
Yeah, exactly. Yeah, 100%.
You've got an overworked DJ sitting in the family court or wherever, and you just want to make sure everything's there, neat, in one place that can be signed off on.
So that's really important. And, there are many of them that people agree, yeah, we agree this, we just want to carry on with it. So that's the first thing. But if it is being contested, yeah, you're right, it's a Form A. And it's either a Form A in a normal process, by which I mean first appointment, FDR, final hearing, the prenuptial agreement is one of many factors, and so on. But in certain cases, you can go for the expedited process. And I'm being very specific about certain cases because it doesn't apply to all cases where there's a prenup. It really is very a limited amount of cases that can go there. And it's really where the prenuptial agreement is going to be determinative to the final award, where it's going to save time, where it's going to save money. And in that case, fast tracking is going to be the option. An example might be both parties are very wealthy, a very short marriage, and there's a prenup, or perhaps where both parties are mature, but it's a very short marriage. Those might be scenarios where fast tracking is a good idea. You need to remember at the back of your head, is it going to be appropriate for a case where there is modest or medium assets, where needs are going to be the main factor in dispute, where there's been material non-disclosure? Then it might not be appropriate to go down the expedited route. So although it's there, although it's great, be really careful about whether you can use it or not in your specific case. And then if you're trying to rely on this expedited route, it's kind of a straightforward process. It's basically an application notice to show cause. It's following the guidelines set out in Crossley, and Sophie, I'm sure, will be able to give you a lot more information about that case if you guys want to know about it.
And that's the 2007 Court of Appeal decision, Lord Justice Thorpe, when there's an application for that. I mean, it's a summons back then, but for that expedited process, and the Court of Appeal say, yeah, this is okay, this is a thing that can be done.
And it is a much quicker process. And it feels a bit weird when you look at it, because you file your Form A and you file your notice to show cause on a Form D11, your Form Z without any documents in support, no questionnaires. In your Form E, you set out why you want your prenuptial agreement to be taken into consideration, or why it should not be taken into consideration. Is it a knockout blow to any financial relief claim, or is it just not to be considered at all?
I mean, I always think that's funny, Melanie, because as you say, that's what the Court of Appeal says. Yeah, you use your Form E in effect to plead your case, and yeah. I mean, that's not really what a Form E is designed to do, and there's perhaps no very obvious place to set out in great detail.
No, and that's why some people would do an affidavit or a sworn statement setting out in more detail the information, but effectively it's attached to your Form E sort of thing, which I'm like, it feels a really weird process. But the idea is you're trying not to go through the whole financial disclosure process, and you're trying to explain why it's not appropriate. And once the court has all the documents, they then set up a hearing for a notice to show cause hearing to look at this. It looks at the prenuptial agreement. It'll also look at other factors. Section 25 does not get ignored just because you're trying to do this.
And it's
important to everything.
Underline that, isn't it, Melanie? That the Section 25 factor, it's not permissible for them to be ignored. So even though you have this intense focus on the nuptial agreement and whether it should be upheld, actually, when the court's looking at it, having gone through the process that you set out in terms of the forms, when the court's actually looking at it, they need also to be taking account of the broader factors. Otherwise, if you're successful, you're going to find that you're not successful for very long, and that the appeal court's going to be out for you.
Exactly. And there can be oral evidence. Apparently, it's mostly written submissions. I think it will really depend on what you're trying to set out, what information you need to put, how complex the evidence is going to be, whether you need to have experts coming to present themselves. It will depend on the judge, but it's presented in that way. And then if the hearing is successful and the judge considers that the prenuptial agreement is important factor that has to be considered, then obviously the matter is concluded and that's it. So instead of going through the whole three-stage year-and-a-half process, it's effectively an application process with one hearing, if you will, to deal with everything.
And then in terms of what you're saying about picking the right case for it, if you're the person wanting to uphold the agreement, what you don't want to do, obviously, is launch into that process when you have a weakish looking agreement. Because you have all of the rigmarole you've spoken about, and then you get to the end of it and actually the judge says, no, hold on, we need to do this in the traditional way.
Well, those are things to consider, is really consider, has the prenuptial agreement been prepared in a way which complies with what we consider to be the Rademacher criteria? Has it been prepared properly? has there been a huge change in circumstances since it was prepared? Do you think the court is going to look at the prenuptial agreement and say, yeah, but actually there are so many other important factors that are now relevant that need to be considered over and above this? And also cost implications. These notes to causes, it's not each party bears their own costs. If you have a weak document or a weak case,
you're in trouble.
So you've got to consider the cost implications. They're not necessarily cheap applications because you're front loading a lot of work into the application. Effectively, the hearing part might be limited in cost, but the actual preparation is hugely expensive compared to the whole of it. So really have a think about whether this works for you or not. I'm not saying don't do it, but I'm saying seriously consider it. So obviously speak to a specialist barrister to make sure that you're not doing something stupid as a solicitor, and that you've got all the boxes ticked, and that you're on solid ground before going any further.
And speaking of specialist barristers, Sophie, what's your take on all of this?
I agree with Melanie, and really the advantage is that you might be significantly curtailing the costs that both parties are going to run up, because if you do have a strong prenup that is likely to be upheld, it's been held in that case of Crossley that it was a factor of such magnetic importance that it would determine and importantly cut short the whole financial application. So in my experience, when a Crossley application is made, what should go with it is a draft order essentially indicating the opposition to the disclosure directions that would follow a Form A being issued, and explaining why really none of this disclosure, this updating stuff is needed, because we know what the position is if the prenup is upheld. And what I have found, unfortunately, is that it's not always rigorously adhered to, that Crossley procedure. So you may end up with some sort of hybrid, for example, a normal first appointment at which the judge, quite often a district judge, will still, however, allow some disclosure but limit it. So some of those questions on that questionnaire, but not all of them. So that's, I think, something to be aware of, that it may not be the slam dunk that you hope for, and that you may still have to almost follow a parallel procedure. What I do object to, though, is whenever it's being described as the preliminary issue. The prenup isn't the preliminary issue, it's the issue in the case. Of course, it's not defying the need of the court to consider with its discretion all the Section 25 factors, but it's not a preliminary issue in that regard.
No, I mean, it's that word, isn't it? Magnetic, and that's the word I think I'm right in saying that the Lord Justice Thorpe uses in Crossley. So that's the sort of case you're looking at. Yes. And sorry, go on.
No, I was going to say that really, this isn't new. We've had the show cause procedure since Dean and Dean in 1978, which reminds us that there's a concluded agreement, and why shouldn't it be kept to? But obviously, we're looking at different factors when we're talking about a prenup.
And just then taking a step away from nuptial agreements or prenuptial agreements, and thinking about international issues, and in particular jurisdiction issues more generally. What about recent things that have popped up in your cases? What sort of things come across your desk?
Well, in terms of a case that I've had, where my client was issuing a divorce in England, the wife was in the meantime issuing a divorce and other concurrent proceedings in Greece, including criminal proceedings and a claim for moral damages, which, if she succeeded, would have had
moral damages.
Yes.
Wow.
Yeah, which, if she had succeeded, would have had an impact on any award that might have been or was about to be made in this jurisdiction. And it was quite important that we got to the bottom of really the likelihood, because unfortunately at this time, and particularly in COVID, just getting a judgment from the foreign court was incredibly difficult. So we hadn't been able to get the outcome of the Children Act matter for a year. We didn't know the impact of the moral damages case, if any, and whether it was going to be pursued and whether it was going to be dropped in light of us arguing about it in this country. And I think it's just keeping all of those strands of these complicated concurrent proceedings in mind, so that you can think about unintended consequences. It may be, of course, that there's absolutely nothing in whatever's being issued abroad, but it's going to have an impact on whether this country can feel that it can confidently decide what the awards will be, whether needs will be met, or is there going to be some siphoning off of money in the near future because of a concurrent claim. In fact, what was made even more complicated was the fact that the divorce petition hadn't even been acknowledged by the other party. And so we were limping on in financial proceedings in England with no divorce petition ever actually having been actively accepted or acknowledged in this jurisdiction.
Sorry, go on.
I was going to say, so one of the things we were trying to do was get a stay of the proceedings in Greece, but that didn't get anywhere. You had to consider whether we wanted a humane injunction. Ultimately, we did manage to resolve it in this country, but it adds to the cost exponentially.
And do you want to say just a word on humane injunctions and the purpose of them?
Yes, so those are an injunction against a person rather than a court, which is why they may have limited significance, because in the recent case of Xanthopoulos and Rakshina, which Alex, I think you brought to my attention because it changes potentially our advice on anonymity. This was a case where, despite the fact that there was a humane injunction against the wife, a court in Russia pronounced a decree of divorce on her application. I like this case because it's really recent, and it was a decision of Mr. Justice Mostyn on the 12th of April this year, but it actually has dual application as to really what necessarily is the impact of a humane injunction, and then the most important thing perhaps in light of the new development on anonymity, which I know that you've been considering.
Yeah, well, just for those listening, anyone who hasn't had a chance to read this decision yet, I mean, headline is you really, really need to read it. Second headline is that basically what's happened is Mr. Justice Mostyn has decided that for all of these years he's been getting it wrong, and that most people have been getting it wrong with him, and that actually there's statutory protection. So, as you may know, the Administration of Justice Act 1960 is part of Parliament's attempt to keep certain types of proceedings away from the public gaze. That protection doesn't extend, he's now decided, to financial remedy proceedings, with one caveat, which is if they're wholly or mainly about the maintenance of children. And therefore, the rubric and all the judgments at the top, that warning is wrong. And the starting point now, certainly if you're here in front of Mr. Justice Mostyn and any lower judge who follows his approach, is that judgments will be made publicly available with the client's names, like open brackets, and shamed, close brackets, unless you apply for a reporting restriction order. So we all, and I dare say we're going to be in big trouble if we don't, we really do, we all need to give our clients advice right at the start of proceedings about the potential impact of this judgment, and what it means in terms of their anonymity if they follow through their proceedings to a hearing at which a judgment is given. I mean, what I'd also say, just taking a step back and thinking about the family justice system more broadly, people will probably know that the Transparency Implementation Group, which is a working group for the President, headed up by Mrs. Justice Leven and Her Honour Judge Reardon, is doing lots of work into these issues. And I dare say they may feel slightly that Mr. Justice Mostyn has jumped the gun in terms of changing the law whilst they're undergoing a very thorough process of considering it. But there you go, just something to bear in mind. Melanie, anything you wanted to add about jurisdiction questions generally?
Yeah, I've got a couple of things that I've been coming up against, particularly in Europe. First, it's delays in getting judgments. If you're waiting for something to happen in Europe to be able to bring it back here for whatever reason, it is taking a huge amount of time for hearings to be finalized, judgments to be drawn up. So be prepared for a long haul. So if you're waiting for a judgment that's been rendered in a European country that you then need to enforce here, it may be taking several months. So factor that into any negotiation, any settlement, any court orders. Be prepared for that huge delay. And that's purely because the courts closed during COVID. And when they reopened up, they had a huge amount of backlog. Something else to consider is I know some European courts, in order to clear that backlog, are simply closing cases that have been inactive for a while. So if you issued a petition pre-Brexit in another country in order to seize that jurisdiction, and then you've done nothing with it, you may find that your application is being dismissed because there's been nothing happening on it. So please go ahead with that and try to speak to the lawyer and get things going on that end. And the other thing is Article 39 certificates. They're still available for proceedings that were issued pre-Brexit. So if they were issued pre-Brexit, but they're finalizing now, you can still get that Article 39 certificate from the court in order to be able to have that divorce finance order implemented in a foreign jurisdiction, or even just to register a divorce in a foreign jurisdiction. But you need to be prepared for a long wait on our side as well, because it is taking the judges a long time to approve those. So it's just a matter of delay, basically. Be prepared for the delays and deal with them appropriately.
One thing that I would add that I see a lot is that we need to remember as international lawyers that whilst from 11 p.m. on New Year's Eve 2020, we left the European legal framework for new cases, that doesn't mean the other European countries did. And so if you take the example of divorce, obviously we now work on a discretionary forum convenient or most convenient location basis, but our friends, neighbours, cousins across Europe may well not be doing that. And I think I'm right in saying that there's not actually a common approach in terms of what our European neighbours are doing with us when they're looking at how, or the extent to which Brussels II Revised should be applied in cases that involve them and us. So it may be they are applying a system that means you have to get there first. That's another reason to think really very carefully at the start of the case about what you're going to do. We've got 2 minutes left. Sophie, did you just want to say a sentence on company valuations and just the headline there?
Yes, I mean, the reality is that that's a topic for an hour on its own. But if we're looking at company valuation issues in this jurisdiction, the approach has been developing and isn't necessarily consistently applied. And so I would just encourage everybody to be aware of the case of Martin, the case of XW and XH, which was also another 2017 decision, and its appeal which was XW and XH 2019, and the case of IX and IY in 2018. Because the reality is that you will need to take specialist advice if you've got company issues in another jurisdiction. The way that we are applying company valuation approaches, as I say, isn't consistent, and therefore it's quite complicated. But you need to take specialist advice in your local jurisdiction if your companies are abroad. And I think, it's quite interesting, isn't it, in light of the Twitter sale this week.
Well, did he get it right? Is his valuation right, Sophie? That's the big question, the $44 billion question.
I'm going to steal the quote from Alexander Chandler QC this week, who said that the EBITDA of Twitter was $52 million in 2021, and Elon Musk just bought it for $44 billion. So that's a multiplier of 845. Take that, forensic accountants, to quote directly.
There you go. Melanie, Sophie, thank you so much for your shared wisdom. Certainly I've learned a fair bit, so I hope that everyone else has too. Like all good international lawyers, Sophie, you're now racing off to the airport, so we'll let you do that. Thank you very much to everyone who gave up their lunch break to attend this. As I say, I think it's been very interesting and informative, and I hope everyone else has found that too. So lovely to see lots of familiar names, and thank you very much.